Hello, my dear listeners. This is your bar exam coach. I am attorney Jennifer Estabilio. In our last session, we discussed the promissory notes or simple loan agreements. Today, we'll take it further and continue with the next part of the lecture, particularly the demand letters up to the information in criminal cases on consummated crimes, frustrated crimes, and attempted crimes. For the demand letters, let's define first what a demand letter is. It is a written communication sent by one party to another, typically to request payment or action in compliance with an obligation, often serving as a precursor to legal action. So what is the purpose of a demand letter? It is to resolve or settle dispute without resorting to litigation. It is also a legal prerequisite of certain causes of action before filing a suit in court. So among all the legal forms under your practical exercises, I bet demand letter is one of the easiest to write because I know that you are well familiar on how to write a demand letter. So what are the elements of a demand letter? We have, of course, the heading and the title, the date and recipient details, the subject heading, introduction, which clearly identify yourself or your client if you are writing on behalf of another, and state the basis of your relationship or the reason for communication. And then the narration of facts, your legal basis, specific demand, deadline for compliance, consequence of non-compliance, and then signature. So here's an example of a demand letter. As stated, you should write a letterhead, okay, and then the date, the name of the recipient, and the address of the recipient. Again, if you recall, I've mentioned last session that if there are no names or addresses given in the bar problem, just leave it blank. Okay? Do not write any unnecessary detail that may distinguish you, no? Because that will be considered as markings. Okay. So write the subject, demand for, blank, and then, of course, the name, dear. Then, I am writing on behalf of my client, the full name of the client, regarding your unpaid obligation under the loan agreement or promissory note, and then dated, write the date of the document. And then narrate the facts, no? According to our client, on or about, then state the date you contracted our client for the what, okay? So you narrate the facts there kung ano ba yung niloan, ano ba yung usapan nila, no? So check the bar question itself. Okay. So however, your aforesaid obligation to our client remain unpaid up to the present. Despite several requests for payment and demands made by our client, you failed and refused to settle the same. Hence, our client was constrained to engage our services to protect its interests. And then third paragraph is to cite applicable laws and then how much, no? The debtor, no, is obligated to pay, okay, or what the recipient is required to do, and then what are you demanding from that recipient, okay, specific action, and then the timeline or days, no, within which to comply with that demand. And then next paragraph is failure to comply with this demand will constrain us to pursue legal remedies, including filing a lawsuit to recover the amount owed at any associated costs, damages, and legal fees. So if you have any questions or wish to discuss potential arrangements for settlement, you may reach out to the undersigned through the contact details provided. Okay, so sincerely, again, okay, so do not write your name, okay? So just write yung ganito lang, signature, name of lawyer, no? Kung on behalf of client siya, roll of attorney's number, IBPPTR, then counsel for the name of the client. So this is easy, no? Simple lang to. You don't need to memorize everything in verbatim. Just know its essence, its essential elements. Okay, ano ba yung essential elements niya? Of course, magpapakilala ka muna. Ano ba yung details ng obligation? Ano ba yung kailangan bayaran? Okay, and then pag may failure to comply with the demand, ano yung gagawin mo? Okay, so ganun lang essentially ang laman ng demand letter. Okay? So do not stress yourself in memorizing all these words in verbatim, no? Pwede naman in your own words, basta kuha nyo, makapture nyo yung essential contents of a demand letter. Next, sale documents of either real or personal properties. Okay. So let's define first. Sale documents of real or personal properties are legally binding instruments that record the evidence that transfer of ownership, no, of real or personal property from one party to another. Okay. So ito yung mga deed of sale, no, ng real and personal properties. So real property, this is what? Immovable, no, objects such as land, buildings, and structures permanently attached to the land. But personal property, this is a movable, no, movable object such as vehicles, equipment, goods, and intangible property. Okay. So under Article 1458, by the contract of sale, one of the contracting parties obligates himself to transfer the ownership of and to deliver a determinate thing, and the other to pay therefore a price certain in money or its equivalence. Okay, equivalent. So the purpose is to transfer ownership, no, of real or personal properties and serves as evidence of the sale and transfer of ownership of a property. So what are the elements? Okay. So napakahaba tong elements, no? Tingnan na lang natin yung form itself para mas ma-visualize nyo. Okay. So let's study the form. So first, okay, you should have the title, no, which is deed of absolute sale. So kailangan meron yan, no, yung pinaka-title nyo. And then, know all men by this presents. Ayan, i-memorize nyo yan. Kasi madalas yung lumalabas sa, kailangan yan lagi nakasulat sa mga any kind of deeds or contracts, no? Yung phrase na yan. Know all men by this presents. So this deed of absolute sale is made and executed in the Philippines by and between. Okay, name of the seller, legal age, Filipino, single or married, to. So important to, no? Ilagay nyo yung name of spouse if given. Okay, so kailangan yan kapag sa mga deed of sale, no? And with residence at seller's address, hereinafter referred to as the sellers. In favor of name of the buyer, of legal age, Filipino, single or married, to, again, name of the spouse, and with residence at the buyer's address, hereinafter referred to as the buyers. Okay. Witnesses. Okay. So, after the witnesses, no, stipulate the description of the property, no? The seller, no, is the registered owner of certain parcel of land situated in blank, covered by what? OCT or TCT ba yan or CCT, no? Check nyo muna yung facts sa problem. Issued by the Register of Deeds of blank containing an area of how many square meters? Okay, more or less. And more particularly described as follows. And then technical description of the property. And then after that describing the property, stipulate the terms and obligations or conditions of the buyer and the seller. Okay. So now, therefore, in consideration of the premises and more specifically of the sum of blank, the receipt whereof is hereby acknowledged from the buyer to the entire satisfaction of the seller, and the seller thus hereby sell, transfer, and convey in a manner absolute and irrevocable in favor of the buyer, his heirs, assigns, and successors in interest, the land above described, together with all the buildings and improvements existing thereon. Okay, and then yung warranty ng valid title. Okay, so familiarize yourself, no, with the essential elements of the deed of absolute sale. Okay, so i-visualize nyo siya, no, i-practice nyo siya on your own. Para pagdating sa bar exam, alam niyo yung position, ano ba yung mauunang ilalagay sa this kind of deed? No? Ano ba yung susunod? Ano ba yung nasa dulo? No? So, i-familiarize yung sarili nyo. Again, no need to memorize word per word. No? Yung mga keywords lang, essential lang. No? So, dito, syempre, ipapakilala mo muna yung seller, ipakilala mo muna yung buyer. Ano ba yung property? Ano ba yung binebenta? And then what else? Ito yung naka-bold letters, no? Yung sell, transfer, and convey in a manner absolute and irrevocable. Siguro yan yung isa sa i-memorize nyo naman. Okay? In transfer of ownership. And then, of course, signature, seller and buyer, and then kung may spouse na nakalagay doon sa inyong bar problem, no, ilagay nyo, no, with my marital consent, spouse of the seller, spouse of the buyer, and then sign in the presence of. Okay, so yun yung mga witnesses. And then lastly, the acknowledgement. Again, as stated in my last lecture, if you still have time remaining in your bar exam, write, no, the complete content of acknowledgement. So parang ganito siya, no? Kung meron man kayong memorize, I encourage you to memorize acknowledgement. Okay? Kasi madalas siya sa mga deeds or contracts. However, kung wala na kayong time remaining at deed of sale naman ang pinapagawa, pero pwede nyo namang ilagay as parenthesis na lang. So, parenthesis yung sa dulo, and then state the word acknowledgement. Okay. For sale documents of personal property, so this is a deed of sale of motor vehicle. So ito yung sinasabi ko, dapat memorize nito, know all men by this presents. Okay. As an introduction, no, dun sa inyong legal form. So yung name ng seller, the personal circumstances, and the description of the motor vehicle, and the next yung amount, no, name of the buyer, address of the buyer, and then the obligation of the seller, yung sells, transfers, and conveys. Okay, so yun yung mga keywords nyo. And by this presents have sold, transferred, and conveyed unto said, the name of the buyer, the aforesaid, motor vehicle yan. Okay, so may correction. So in witness whereof, I have hereunto set my hand. Okay, yung date, seller, buyer, and then the witnesses. And then again, the acknowledgement portion. Okay. Next. For lease contract, ito halos kamukha lang din naman ng deed of absolute sale. Kaya kung familiar na, no, sa inyo ang deed of absolute sale, madali nyo na itong magagawa, yung lease contract. Okay, so let us define first what a lease contract is. A contract of lease is an agreement where the lessor obliges themselves to give the lessee the enjoyment or use of a thing for a price certain and for a specific period. The purpose of this is to bind the lessor to give the other party, the lessee, the enjoyment or use of a thing for a price certain and for a period which may either be definite or indefinite. So for the elements, no, essential elements, so this is a sample of a lease contract. So again, memorize, know all men by this presents. Okay. Huwag niyo muna kalimutan yung pinaka-title ha. So for this particular legal form, yung lease contract or contract of lease. Okay. So know all men by this presents. This lease contract is made and executed in blank kung kailan siya na-execute. Again, kamukha nung deed of absolute sale, di ba? So may name ng lessor. Okay. Personal circumstances, and then name of ng lessee. Okay, so for the contract of lease, hindi naman kailangan na ilagay yung spouse, no? Kasi wala namang transfer or conveyance of ownership dito ng property. No, nililis lang naman eh. So, hindi siya, kumbaga, substantial requirement. Okay, however, if in the given problem, kung may nakalagay naman ng name ng spouse, ilagay nyo lang din siya as part of the personal circumstances of the parties. Okay. So witnesses, whereas the lessor is the absolute unregistered owner of residential property described as blank, referred to as the leased premises, and then ilagay nyo lang, no, yung details kung kailan ba duration of the lease, magkano ba ang payment, okay, ano ba yung terms and conditions, okay. So, yung purpose, yung term, ayan, rental rate, okay, kung may security deposit ba. So, mababago na ito. It will depend on the facts stipulated in the given problem. Okay, so pwede itong ma-modify. So, again, just familiarize yourself with the essential elements. No need to memorize this again in verbatim. Okay? So, after the terms and conditions, okay, yung date again, no? Signing of the contract of lease. Okay, yung signing, lessor and lessee, and then lastly, the acknowledgement. Okay, so there's again minor correction now in the slide. So that should be, we have here to sign this contract of lease or lease contract. Okay, correct nyo na lang yan. So lessor and lessee, and sign in the presence of, for the witnesses, and then the acknowledgement. Next is the special power of attorney to sell a realty or appear in pre-trial. Okay, so let us define first what a special power of attorney is. It is a legal document that grants a person called the agent or attorney in fact the authority to act on behalf of another person called the principal for a specific limited purposes. So the purpose of this is when a person, no, yung principal, cannot personally carry out a specific legal act such as selling property, entering into a contract, or attending a legal proceeding, no? For this particular case, yung appearing pre-trial, no? It allows another person to act on their behalf for that specific purpose. Okay, so let us study the essential elements of a special power of attorney. Again, write the title. Okay, special power of attorney. And then, know all men by this presents. Oh, pang ilang legal form na yan, dapat kabisado nyo na. Okay? Next, personal circumstances of the principal. Kaya ano ba yung personal circumstances niya? Of course, the name, legal age, citizenship, civil status, and then the address. Okay, so yun ang unang ilalagay. Okay, do hereby appoint, name, and constitute. Ayan, importante yan, no? A and C. Appoint, name, and constitute. Kung meron man kayong i-memorize sa SPA, ito yung mga keywords, no? Itong mga appoint, name, and constitute. And then, write the name of the agent or attorney in fact. Okay, and then the personal circumstances of that agent or attorney in fact. Okay, as my true and lawful attorney in fact, ayan, memorize nyo rin yung phrase na yan ha, as my true and lawful attorney in fact, for me and in my name, to do and perform the following acts. Now, if you will, no, you will stipulate, no, in the acts, no, yung performance of these acts, kung about sa selling of a realty, so you will write, no, you will stipulate to sell, offer for sale, or come to an agreement, or sell, transfer, and convey. Basahin nyo na lang ito, okay? So you may take a screenshot and then just read these 6 acts, okay? So no need, again, no need to memorize this in verbatim. Familiarize nyo lang, kasi dito ang cover na inyong bar exam is to sell a realty. So ano ba yung mga kailangan yung i-authorize sa agent to be able to perform yung selling of a real property? Mas lagay dyan, execute, deliver, sign, collect any proceeds, okay? So pay any unpaid taxes. So mababago yan, no? Depende sa given na problem. Okay, so hereby giving and granting unto my attorney in fact the full and authority to execute and perform all and every act as to carry into effect the foregoing powers, as fully to all intents and purposes as I might or could lawfully do if personally present, and hereby ratifying and confirming all that my attorney in fact shall lawfully do or cause to be done. And then the date, no, kailan nag-take effect, and then and all matters relating to this SPA shall be governed by the laws of the Republic of the Philippines. And then kung kailan na-sign, okay, in witness whereof, I have hereunto set my hand this blank, okay, date at the place of execution. And then name of the principal. And then pwede ring may witness. So dito, mapapansin nyo as you can observe, no, as you observe, only the name of the principal is stipulated. Okay, hindi na kailangan yung signature of the attorney in fact. Okay. And then lastly, there should be an acknowledgement. Okay. For the special power of attorney to attend in pre-trial, so as you can see, so this is similar to the SPA to sell a realty. The difference is the performance of the acts. Okay, here, the performance of the acts are as follows. So first, to appear before any court or quasi-judicial body. Okay, and then write the case title of the case and the case number. And then, in which court, no? Ilagay nyo yung details. No, kasi pre-trial yan pupunta yan sa court. Okay. Second, to participate in the pre-trial conference. Okay. Enter into stipulations or admissions of facts, submit alternative modes of dispute resolution, and enter into a compromise agreement or amicable settlement. Third, to sign pre-trial briefs, manifestations, motions, and other pleadings, okay, incidental to the pre-trial. And then lastly, to sign, execute, receive, and or deliver all other documents on my behalf, okay. So again, no, the format, the positioning of the details are almost the same, okay. The difference only is the consent of the second paragraph, which is the performance of the acts of the attorney in fact. Okay, so mabilis nyo na yan may memorize kumbaga. Mapafamiliarize nyo na sarili nyo kasi makakamukha lang din naman sila. And then lastly, yung acknowledgement. Okay? Here, verification and certification against forum shopping. Verification is a statement under oath. No, it includes both the actual swearing to the truth of the statements by the subscriber and also the certification thereto by the notary or other officer authorized to administer oath. While forum shopping is an act of a party against whom an adverse judgment has been rendered in one forum, or seeking and possibly getting a favorable opinion in another forum, okay, other than by appeal or special civil action for certiorari, or the institution of two or more actions or proceedings grounded on the same cause on the supposition that one or the other court would make a favorable decision. Okay. So yung verification, no, you are swearing to the truthfulness of the statements. Yung forum shopping, as the word itself, no, shopping, ibig sabihin marami kang pinuntahan, nag-shopping ka. Ano yung forum? Ito yung mga courts or tribunals. So dyan sa forum shopping naman, maraming pinuntahan, no, na tribunals or any other forum seeking favorable opinion, no, on the same cause of action. So yan yung prohibited. Okay? Kaya in every initiatory pleading, no, like for example, the complaint, we attach a verification and certification against forum shopping. Okay. So the purpose of verification is intended to secure an assurance that the allegations in the pleading are true and correct, and not the product of imagination or a matter of speculation, and that the pleading is filed in good faith. In certification against forum shopping, it ensures that parties do not simultaneously seek relief for the same cause of action in multiple courts or tribunals, preventing the possibility of conflicting rulings and wastage of judicial resources. So we have here the elements of a verification and certification against forum shopping. Okay, so the name of the party, executing the document, the personal circumstances, and then the attestations. And then lastly, jurat. Okay, so hindi na ito acknowledgement ha. Take note, jurat na. Okay, so here's an example of verification and certification against forum shopping. Okay, so kung meron man kayong memorize, no? Kasi ang advice ko dun sa mga naunang legal documents is just to familiarize yourself with the essential elements and then yung mga keywords only. However, in verification and certification against forum shopping, I encourage you to memorize all of these 6 stipulations. I-memorize nyo yan. Why? Because these are provided by your revised rules of court, no? In your civil procedure. Ito na talaga yung nakalagay doon. So you need to memorize this. Pag ito ang pinadraft sa inyo at memorize nyo ito, okay. So okay ka na dyan. Nagawa sa practical exercise mo. Okay. So first, I, the name, no, Filipino citizen of legal age and with address, okay, stipulate the address. After having been duly sworn according to law, hereby depose and state that. Okay, so for the first 4, okay, first 4 statements, okay, these pertain to verification, yung 1 to 4. But for number 5 and number 6, no, these pertain to certification against forum shopping. Okay, so dapat, when you write a verification and certification against forum shopping, you need to write all of these 6 statements. Kasi baka mamay nakulang kayo number 6, kasama yan dun sa certification against forum shopping. That's why I encourage you to memorize all of these 6 statements. Okay. So number 1, I am the complainant in the above entitled case and have caused the preparation of this complaint. Number 2, I attest that the allegations in this complaint are true and correct and based on my personal knowledge or based on authentic records. My signature appearing herein serves as a certification of the truthfulness of the allegations in this complaint. Number 3, I attest that the pleading, is not filed to harass, cause unnecessary delay, or needlessly increase the cost of litigation. Number 4, I attest that the factual allegations in this complaint have evidentiary support. Or after reasonable opportunity for discovery will have evidentiary support. And then number 5, I have not therefore commenced any action or proceeding, nor is there any action or proceeding to the best of my knowledge, personal knowledge, pending in the Supreme Court, the Court of Appeals, or in any other court, tribunal, or agency against the same parties involving the same cause. And number 6, should I hereinafter learn that a similar action or proceeding has been filed or is pending before the Supreme Court, the Court of Appeals, or in any other court, tribunal, or agency, I undertake to notify this honorable office within 5 calendar days therefrom. So these are very important stipulations. Pati yung within 5 calendar days, no? Kailangan yan ilagay nyo. So you need to memorize these 6. And then lastly, in witness whereof, I have affixed my signature, the date, and then affiant. And then memorize this, yung jurat. Subscribe and sworn to before me this blank day of blank, affiant personally appeared before me and exhibited to me his or her competent evidence of identity. Containing his or her name, picture, and signature, and the notary public. So write the jurat, the content of the jurat. Next, preliminary statements and attestations in judicial affidavits. So judicial affidavit is a written sworn statement of a witness that replaces direct oral examination during court trial. It is a question and answer format of testimony and submitted to the court in advance of the hearing. So dito, because of judicial affidavit or JA or JUDAF, mas mapapadali na ang court trial because this replaces direct oral examination. So tuloy na sila sa cross-examination. In criminal cases, the judicial affidavit serves as a substitute for the direct testimony of the witness, thus streamlining the process and reducing the time needed for witness testimonies in court. The use of judicial affidavits is designed to expedite proceedings, particularly in lower-level criminal cases, where the maximum penalty does not exceed 6 years. Take note of the conditions. So there are 2 conditions. First, where the maximum penalty does not exceed 6 years, you should use, mandatory to, judicial affidavit. Pag ang penalty does not exceed 6 years. However, if the penalty exceeds 6 years, judicial affidavit is now discretionary. Depende yan, kailangan merong consent si accused to use a judicial affidavit. Maging discretionary siya. Pero pag lower than or does not exceed 6 years, mandatory ang use ng judicial affidavit in criminal cases. So attestations refer to the formal statements by the witness acknowledging the veracity of the content and by the lawyer certifying compliance with ethical and procedural requirements. The purpose of this, again, is to reduce the time needed to complete the testimonies of witnesses, thereby speeding up the hearing and adjudication of cases and addressing case congestion and delays that plague the courts. So we will discuss these attestations of the witnesses and of the lawyer when we go on or we go over the legal form itself. Here. So for visualization, kasi importante ma-visualize nyo ano ba yung itsura ng judicial affidavit. Mas maaalala nyo kasi kapag application na. So first, write the heading, the Republic of the Philippines, National Capital Region, Regional Trial Court, so branch and then blank. So this heading may vary depending on the given bar question. Okay. So the caption, People of the Philippines, plaintiff versus the name of the accused, and then accused, criminal case number blank for violation on blank. Okay, so the title, no, judicial affidavit. And then, the name of the witness, no? Yan yung ini-interview ng lawyer, no? Siya yung magte-testify, witness. Name of the witness and the witness's personal circumstances, okay? After having been duly sworn to in accordance with law and in answer to the following questions, do hereby depose and state that. So, preliminary statements. The person examining me is Attorney Blanc, okay, with office address at Blanc, yung address niya. This judicial affidavit is being taken at what location, okay? Kung hindi naman given sa problem, just leave it blank, no? In parenthesis nyo na lang. Put a parenthesis, okay? Purpose of testimony. Okay, lagay nyo rin yan. To prove that the affiant is the private complainant in this case, to establish the material allegations in the complaint, and to identify relevant documents and circumstances surrounding the case. So, I am executing this affidavit freely and voluntarily, fully aware of its contents, and of my obligation to tell the truth, and fully conscious that in answering the questions asked of me, I am answering under oath and I may face criminal liability for false testimony or perjury. And the next, yung questions and answers. Okay? For the questions and answer portion, so yung first part dito, no, you establish first, no, who is your witness, what is the name of your witness, the address, the age, occupation. Okay, so in-establish nyo muna, no? Pinapakilala nyo muna yung witness. And then susunod, do you know the accused in this case? Okay, so, and then yung narration ng incident. Okay, so, i-imagine nyo lang kumbaga, i-visualize nyo lang yung magiging flow of conversation nyo with a witness. So, yun yung maging Q&A. Okay, so, introduce first the witness in the form of Q&A, and then if he or she knows the accused, and then the narration, kung na-witness niya ba, siya ang complainant, anong nangyari sa kanya. Okay? And then lastly, is there anything else you would like to add? Okay, so yun yung mga final statement. And then lastly, yung nothing further. And then after that, after the Q&A, write the witnesses attestation. No? So part ito, kailangan nyo rin ito i-memorize. Okay? In witness whereof, I attest that I have read this judicial affidavit and the same has been explained to me in blank dialect that I fully understand, and that the facts stated herein are true and correct to the best of my knowledge. I further attest that I understand I can be charged with perjury if I make any false statement. So the affiant and then jurat. No, may jurat dyan after the witness's attestation. And then next, lawyer's attestation. No? So, name of the lawyer and personal circumstances, no, hereby state under oath that I conducted supervised examination of the name of the witness. I faithfully recorded the questions I asked and the answers given. No coaching or influence was exerted on the witness at any time during examination. Okay. And then, of course, the date of signing and then jurat. Okay, so dalawang jurat dito ha. Okay, so again, so this is very important. You need to memorize, no? Its essential contents, no? Its elements. Okay, so memorize na yan. So the heading, the caption, the title, the preliminary statements, the Q&A, and then the witness attestation, jurat, lawyer's attestation, and then jurat. Okay, dalawang jurat. Next, notarial acts. So notarial acts are governed by 2004 rules on notarial practice. So these shall be applied and construed to advance the following purposes: to promote, serve, and protect public interests, to simplify, clarify, and modernize the rules governing notaries public, and to foster ethical conduct among notaries public. Okay. So for the jurat, no, this refers to an act in which an individual on a single occasion appears in person before the notary public and presents an instrument or document, is personally known to the notary public or identified by the notary public through competent evidence of identity, and then signs an instrument or document in the presence of the notary and takes an affirmation or oath before the notary public as to such instrument or document. Okay. Para mas maintindihan nyo ito, imagine yourself, you are the notary public. So there's a person, no, coming to you. And then may hawak siyang document. So that person appears before you. no? And that person presents an instrument. Okay, kung kilala mo siya, okay, hindi na kailangan ng ID. However, kung hindi mo naman kilala, and then for identification, you need to require that person to submit a competent evidence of identity. And then that person will sign the instrument, no, in your presence. And then he or she will take an affirmation or oath before you, no? Take siya ng oath. Okay. So, imagine nyo siya para mas madali nyo siyang maintindihan. Okay. So, this is a form for jurat, okay, Republic of the Philippines, City or Municipality of blank, subscribe and sworn to before me this blank day of blank, affiant person appeared before me, no, and exhibited to me his or her competent evidence of identity containing his or her picture and signature. So this is very short. Ang pinaka-important dito nag-subscribe and nag-sworn to before the notary public, yung affiant. No? Kaya very short lang ito. And then notary public, document number, page number, book number, and series number. Okay. For acknowledgement, ito yung mas mahaba. No? So acknowledgement, the same din sa letter A and letter B. No? So there's a person coming to you. No? You are the notary public, meron siyang nare-represent din, no? So, represents to the notary public that the signature on the instrument or document was voluntarily affixed by him for the purposes stated in the instrument or document, and declares that he has executed the instrument or document as his free and voluntary act and deed. So, these are the important keywords in writing and an acknowledgement, okay, that the person declares that he has executed the instrument or document as his free and voluntary act and deed. Okay, hindi siya pinilit, no? Voluntary siyang pumirma doon sa document na yon. Yun ang sinasabi diyan sa acknowledgement. Okay, so mas longer version ito, no? So, the title, Acknowledgement, Republic of the Philippines, City or Municipality of, before me, okay? In notary public, for and in the blank, personally appeared the following. Okay, so yung name ng parties, known to me to be the same person who executed the foregoing instrument and acknowledged that the same is his or their free act and voluntary deed. Okay, again, yan yung important keyword. This instrument, consisting of blank pages, including this page upon which the acknowledgement is written, has been signed by the parties and their instrumental witnesses on each and every page and on the space provided for the signature. Okay, and relates to, okay, kung ano yung document, no? Kung yan yung deed of sale, kung relates to the parcel of land, okay? Sale of land. So, witness my hand and seal at blank and the notary public, and then document number, page number, book number, series of blank. Okay. So, nakita nyo, no? Doon sa jurat nakalagay, subscribe and sworn to me. Kasi nagtitake ng oath of affirmation yung client nyo or yung person Dito naman, hindi nakalagay yung subscribe and sworn to me, no? Before me nakalagay. May nag-appear sa inyo, personally appeared, no? Na ina-attest nyo, ina-acknowledge niya na ginawa niya, in-execute niya yung instrument na yon in his free act and voluntary deed. And then meron ding witnesses na nag-sign. Okay, so magkaiba, no, ang jurat and acknowledgement. So wag kayong mali dito, ha? Okay. So, in an acknowledgement, the notary certifies that a person appeared before them and acknowledged executing the document. In a jurat, the notary administers an oath or affirmation that the contents of the documents are true and the signatory signs the document in the notary's presence. Okay. An oath or affirmation is a promise to tell the truth or to perform a particular duty. It is often used for affidavits or sworn statements, while acknowledgement is about verifying the identity of the document signer and the voluntary nature of the execution. Okay, so take note of their difference. Okay? Next, as part of the Notarial Act, copy certification. Okay, so from the word itself, ano ba yung copy certification? Okay, so copy. You are duplicating a copy. After you duplicate a copy, what will you do as a notary public? You will certify. No? So, tingnan nyo lang yung mga keywords. Okay, so copy certification refers to a notarial act in which a notary public is presented with an instrument or document that is neither a vital record, a public record, nor publicly recordable, copies or supervises the copying of the instrument or document. So, pwedeng si notary public mismo mag-copy or supervises no, the copying of the instrument. Compares the instrument or document with the copy, okay, kung tama ba lahat yung na-copy, and determines that the copy is accurate and complete. So, yung sinacertify niya, no? Na accurate and complete yung pag-copy, the copying of that document. Okay, so this is the certification. So, first, Republic of the Philippines, City or Municipality of Blanc, SS, copy certification. Kasi ikaw yung as a notary public, no? Notary public ang testify dito. Name of the notary public, a duly commissioned notary public for and in the City or Municipality of Blanc, Republic of the Philippines with notarial commission number valid until blank, hereby certify that on the date, no, and then the office, the following instrument or document was presented to me by the name of the party who is personally known to me or identified by me through a competent evidence of identity in accordance with the 2004 Rules on Notarial Practice. So the description of document, I compared the attached copy with the original document and I hereby certify that the attached copy is true, correct, and complete copy of the original. And then witness my hand and seal, the day and the notary public, document number, page number, book number, series of the... Okay. So, familiarize yourself ha. Memorize nyo rin ito. Yung content of a copy certification. Okay, next, motions. Motion is an application for relief other than by pleading. It is a formal request submitted to the court for a specific order or ruling related to a pending action or proceeding. So a motion by which a defendant, for the motion to dismiss, no, it is a motion by which a defendant seeks the dismissal or termination of an action or proceeding before filing a responsive pleading or before a full-blown trial. So we have 4 grounds of a motion to dismiss under 2019 Revised Rules of Civil Procedure. We have LLRP or L, lack of jurisdiction over the subject matter, litis pendentia, res judicata, and prescription. Okay. Rule 15 of the Revised Rules of Civil Procedure covers general rules on motions. So the other grounds provided under Rule 16 of the old 1997 Rules of Civil Procedure must now be raised as affirmative defenses in the answer. So kung may motion to dismiss kayo, ang dapat lang na ground, no, itong 4 ang makita sa motion to dismiss nyo. Titingnan nyo, depende sa bar question, ano ba yung ground no, ng movant in filing the motion to dismiss. Kung res judicata lang yan, then res judicata lang ilagay yung ground. Kung litis pendentia lang yan, then litis pendentia. No? Basahin nyo maigi yung bar question. Okay. So the purpose of this is to terminate a case without the need for a full-blown trial when there are legal, procedural, or jurisdictional grounds that render the compliant defective or unjustifiable. Okay. So for the motion to dismiss, no? So this is the format. Okay. The heading, Republic of the Philippines, RTC, okay, the judicial region, the branch, the city, the caption, the name of the plaintiff, name of the defendant, and then the case number, the title, motion to dismiss, okay, defendant through counsel respectfully states, and then the background, no, brief background introduction, and then you write the grounds for dismissal, your arguments, and then the prayer, okay. So, lastly, okay, yung defendant prays for such other reliefs are just and equitable under the premises, the date and filing, respectfully submitted, and then the name and signature of the counsel, and copy furnished, no, yung opposing counsel, or yung plaintiff's counsel, kailangan i-copy furnish. And the notice of hearing, ayan, to the branch clerk of court. Okay, then please take notice that the foregoing motion to dismiss shall be submitted for approval and consideration of the honorable court as soon as the counsel and matter may be heard. And then explanation, kung hindi siya personally serve to the other party, so ilalagay, service of this pleading is done through registered mail to the honorable court and defendant's counsel due to distance and lack of office personnel to effect personal service. Okay? Next is motion to declare defendant in default. It is a formal written request by the plaintiff asking the court to declare the defendant in default due to the latter's failure to file an answer or responsive pleading within the reglementary period provided under the rules of court. Okay. So, kailan lang ba, no? If the defending party fails to file an answer within the time allowed. Okay. So, the claiming party may file, no? Before the court with notice to the defending party and prove such failure to declare the defending party in default. Okay. Paano ba yung format niyan? Okay. So, kamukha lang din ng motion to dismiss, no? Meron pa ring heading, the caption, the title, okay, and then yan, plaintiff, no? By the undersigned counsel, and then stipulate nyo lang, no? Kailan nabigyan ng copy yung defendant, anong date, kailan niya na-receive, okay, yung summons, no? And then, the defendant has not filed any answer or any motion, no? Or any permissible responsive pleading, kaya pinapadeclare nyo na siya in default. Okay, so pursuant to Rule 9, Section 3 of the Rules of Court, the failure of the defending party to file an answer within the time allowed with no justifiable reason or excusable negligence warrants his or her declaration default. Okay, and then number 6, once the defendant is declaring default, plaintiff prays that this honorable court allow plaintiff to present evidence ex parte and thereafter render judgment in accordance with the evidence and reliefs prayed for in the complaint. Then your prayer to declare defendant in default and to allow plaintiff to present evidence ex parte. Okay, and then of course the date, signature, and then copy furnish the other party. Okay, so familiarize yourself with the essential elements and contents of a motion to declare defendant in default. Ang important dito to stipulate is the date, no? Kailan na-receive. Yan yung wag niyo kakalimutan. Date of receipt of the complaint or kung ano mang pleading yan. And then, yung word na failure of the defendant to file, no? Any permissible pleading within the time allowable by the rules of court. So, yan yung mga keywords na kailangan yung mailagay, no? When you write a motion to declare defendant in default. And then, of course, your prayer. And then, notice of hearing. Okay? Execution of judgment, no? Motion for execution of judgment. It is the process by which a prevailing party enforces a court's final judgment or order. No? So the judgment or final order attains finality when no appeal or motion for reconsideration is seasonably filed. Okay, so once finality is established, the judgment cannot be modified or set aside except in very rare circumstances. So we have other grounds, no? Yung annulment of judgment, petition for relief, or Rule 65. Okay. So execution shall issue as a matter of right or motion upon a judgment or order that disposes of the action proceeding upon the expiration of the period to appeal if no appeal has been duly perfected. No? Or if the appeal has been duly perfected and finally resolved, no, pwede nyo nang pa-execute yung judgment. Okay, so the purpose of this is to what? Of course, enforce or execute a final and executory judgment. So what is our format? So this is our format. Again, the heading, the caption, no? Pare-pares lang yan. Kaya kailangan by this time memorize nyo na, no? And then the title, motion for issuance of writ of execution. Yan, yung title niya. And then comes now, okay, the name, kung plaintiff man yan or defendant, okay? Through counsel and to this honorable court states a decision dated blank was rendered by this honorable court in favor of the movant. Ordering blank, kung may dispositive portion, ilagay nyo. No appeal or motion for reconsideration has been filed within the reglementary period. Then by virtue of Rule 39 of the Rules of Court, the prevailing party is entitled to a writ of execution as a matter of right. Okay, so wherefore, premises considered, it is respectfully prayed that this honorable court issue an order directing the clerk of court to issue a writ of execution to enforce the judgment. Then other reliefs, just and equitable, are likewise prayed for. And then the signature of the counsel. And then, this is the writ of execution, no? This is addressed to the sheriff, then signed by the clerk of court. Okay? Pero kung sa tanong naman, di naman kayo pinapagawa ng writ of execution, just a motion for issuance of writ of execution. So, just write itong sa motion for issuance of writ, no? No need to write yung nasa right portion, yung writ of execution. Okay, ito lang. Okay, yan lang, right? Pero kung sabi sa problem, write also o draft also a writ of execution, so ito siya. At least you know. Okay? So the heading, writ of execution to the sheriff, okay, and then greetings, no? Whereas on blank, a judgment was rendered by this court. Okay, yung title and the number. The dispositive portion of which reads as follows. Quote the dispositive portion of the judgment. So the said judgments have become final and executory. Now, therefore, you are hereby commanded, no? Inuutosan dito yung sheriff ng clerk of court, no? So part na ito ng clerk of court. You are hereby commanded to enforce and satisfy the aforesaid judgment together with the cause of suit in the manner provided by law. You shall make a return of this writ to this court within the time period specified by the court, stating the proceedings you have taken. So fail not under penalty of law, issue this, the date, and by authority of the court, clerk of court. Okay. Quitclaims in labor cases. So quitclaims are contracts in the nature of compromise where parties make concessions, a lawful device to avoid litigation. So it is a valid and binding agreement between the parties, provided that it constitutes a credible and reasonable settlement, and the one accomplishing it has done so voluntarily and with a full understanding of its import. Okay. So the purpose of quitclaims is to enter into equitable compromise, no, ito yung sa mga employer and employee, no, to avoid future disputes or litigation. So we have here a form, no, for quitclaim release and waiver. Okay, so write the title, and then again, yan, memorize nyo na yan. Know all men by these presents. The name of the employee. Kasi ang nag-execute ng quitclaims, the employee, no? Sinasabi lang naman sa quitclaim na hindi na siya, kumbaga, in layman's term, maghahabol doon sa employer niya dahil may na-receive na siyang compromise, no? Na amount. Okay? May consideration na. Okay. So, the name of the employee, legal age, Filipino resident, hereby state that. So, establish nyo muna. So, sino yung employer niya? Lagay nyo, kailan siya na-hire? Kailan siya separated dun sa employment niya or terminated, no? The parties have arrived at an amicable settlement regarding all monetary claims and obligations between me and the employer arising from my employment and or cessation thereof. For and in consideration of the sum, okay, magkano ang na-receive niya? The receipt of which I hereby acknowledge in full, I forever release and discharge the employer, its officers, directors, managers, agents, successors, no, from any demands or cause of action or liabilities. Okay. Number 4, I confirm that I have read and understood every stipulation is quitclaim, release, and waiver, and that I have executed these voluntarily and without any force, intimidation, or undue influence. Number 5, I hereby waive any and all rights that I may have under Philippine laws. Okay? So, this is the content of a quitclaim, release, and waiver. Okay? So, meaning, dyan, the employee will no longer hold the employer liable, no, in the future, no, because of the amicable settlement that they had, and for the receipt of a consideration, no, yung kung magkano man yun. So, forever release and discharge, and then wini-waive na yung kanyang right. Okay, so just understand, no, just understand the essential elements of this legal form, no, no need to memorize in verbatim, no? Tingnan nyo lang, paano ba yung flow? Paano ba yung flow ng legal form na ito? Ipakilala nyo muna si employee, sino yung employer niya, kailan siya na-hire, ano ba yung nangyari, no? Ano ba yung usapan nila? May amicable settlement, and then, magkano ba yung na-receive niya? And then, ano ba yung wini-waive niya, yung mga rights niya against the employer? Nire-release niya rin yung employer from any liability. So, ganun, no? You may state in your own words, okay? And then, the signature of the employee, okay, with my voluntary and informed consent, ayan, an acknowledgement yan ha, kasi ano yan eh, acknowledgement, di ba? Voluntary and free act, no? Free act and voluntary deed. Okay, kung maalala nyo. So, dito kasi about yung voluntariness of execution of this document, kay acknowledgement siya. Hindi lang siya jurat, no? Okay. Lastly, no, last topic, information in criminal cases. An information is an accusation in writing charging a person with an offense subscribed by the prosecutor and filed with the court. So we have consummated, frustrated, and attempted felonies. Okay. So ang information, iisa lang ang kanyang format. Nababago na lang sa content, whether is it consummated, is it frustrated, or attempted. So dun lang ma-vary, dun lang magkakaroon ng variation. So you should know, no, the definition first, no? Kailan ba siya consummated, kailan frustrated, kailan attempted, no? Kasi nilalagay niyo sa information. So a felony is consummated when all the elements necessary for its execution and accomplishment are present. And it is frustrated when the offender performs all acts of execution which would produce the felony as a consequence, but which nevertheless do not produce, no, it by reason of causes independent of the will of the perpetrator, no? Independent sa will niya. Ginawa niya lahat ng execution, no, to accomplish that crime, no, or that felony, pero hindi na-produce daw, no? Independent, no, sa kanyang will. Merong ibang nangyari. And then there's an attempt when the offender commences the commission of a felony directly by overt acts, but does not perform all the acts of execution which should produce the felony by reason of some cause or accident other than his own spontaneous desistance. So dito, hindi pa na-perform lahat, no? Bakit hindi na-perform? Dahil may ibang reason. But other than his own spontaneous desistance. Hindi siya mismo kumbaga voluntarily na nag-desist. Gusto niya talagang gawin yon. Pero may ibang outside the external circumstances that happen resulting to not producing that felony. Okay. So the purpose of this is to inform the accused of the nature and cause of the accusation against them, and to enable the court to acquire jurisdiction over the person of the accused and subject matter of the accusation. So this is jurisdictional, no? Yung information, kasi binabasa to no? Binabasa, in-inform, no? Ang accused on the nature of the and cause of the accusation against the accused. Okay. So here, this is an example of information, no? On homicide. Okay, so consummated ito consummated crime. So first, write the heading, okay, and then the caption, and then the word information. The undersigned prosecutor accuses the name of the accused of the crime committed as follows. Okay, so that on or about the date in the city of blank, within the jurisdiction of this honorable court, the said accused, with intent to kill and without any justifiable cause, did then and there willfully, unlawfully, and feloniously attack, assault, and stab one, in the name of the offended party, with a bladed weapon, hitting him on the vital parts of his body, thereby inflicting upon him mortal wounds which caused his death soon thereafter. So consummated kaya namatay, no? Inflicting mortal wounds which causes death, namatay. So, yan yung mga keywords, no? Kung homicide yan at consummated ang pinapagawa sa inyo na information, so kailangan namatay. Okay? Okay, for example of homicide. Okay? Kung murder naman yan, dapat sa content ng information nyo, write the aggravating circumstances leading to murder. Okay? So, you need to know your criminal law. Okay, you need to know yung mga crimes, no, under the revised penal code para magawa nyo tong legal document na ito, itong information na ito. Because you will state here the elements of the crime. Okay? So, kung murder yan, ano ba yung aggravating circumstance that led to murder? No? So, you need to understand first your substantive law, no? Bago kayo makakasulat nito. Okay? So, contrary to law, place and date of filing, and then the name and signature of the prosecutor, and then the witnesses. Certification. Okay, may certification ang prosecutor. I hereby certify that I have conducted a preliminary investigation in the above entitled case, having taken the testimony of the witness under oath, and the accused was given a chance to submit controverting evidence that on the basis of the evidence presented, that there is a reasonable ground to believe that the crime of homicide in violation of Article 249 of the RPC has been committed, and that the accused is probably guilty thereof. Subscribe and sworn to before me this blank date in the blank place, Philippines. Okay, so name and signature of the prosecutor and title or position. Okay. For the frustrated crimes, okay, so let's read the second paragraph, no? Yung elements. Okay. So, with a bladed weapon, okay, doon na tayo ha, kasi halos parehas lang naman doon sa preliminary statements, yung date, yung place, name of accused, and the name of offended party. Okay, so yun yung mga kailangan andyan, no? Date, place, no? Name of accused and name of offended party. With a bladed weapon, performing all the acts of execution that would have produced the crime of homicide. Okay, so the designation of the offense should be there. As a consequence, but which was not produced by reasons independent of the accused's will. To wit, the timely and efficacious medical intervention which prevented the death of said offended party, thus leaving the said crime at its frustrated stage. So, kailangan very clear, ha? Kung frustrated crime ang bar question, okay, you need to write these words, no? Which was not produced by reasons independent of the accused's will. Ano ba yung nangyari? Independent of his will. Yung timely and efficacious medical intervention, no, which prevented the death of the offended party. Mag-vary ito, depende kung ano rin yan sa problem. Take note of that, okay? Thus, leaving the said crime at its frustrated stage. Okay, so hindi siya namatay, no? So, contrary to law, again, similar lang dun sa nauna, and then the certification. Okay? Next. Last. Okay. Last form, no, legal form under practical exercises, no, information in criminal cases for attempted crimes. Okay? So again, parehas lang yung mga preliminary statements, yung heading, caption, title. Okay, ano lang na iba? Ano ba yung crime committed? No? So, for this one, attempted homicide. Okay? So, you write the elements. So, here, no? Sabi dyan, the above name accused with intent to kill and having commenced the commission of such offense by overt acts. Okay, take note of the keywords, no? Overt acts. Kasi attempted na eh. Did then and there willfully, unlawfully, and feloniously. And then state the specific overt acts. So, for instance, kung nasa bar question, attack, assault, or use personal violence, no? Or aiming a firearm, and pulling the trigger. So, yan yung mga overt acts. Okay, so ilalagay nyo. Thus, commencing the commission of the said offense directly by overt acts, but the accused did not perform all the acts of execution, which would have produced the crime of homicide by reason of causes other than his or her own spontaneous desistance. To wit, so ilalagay nyo ulit, ano ba yung nangyari? No, bakit hindi niya na-perform all the overt acts? So, explain the external or intervening causes. So, for instance, the firearm malfunction, the victim ran away, or someone grabbed the accused arm. So, it will depend, no? Based on the facts given in the bar question. But the important thing is to memorize the keywords. Okay, so I highlighted, no, the important keywords that should be on your legal form. Okay, so contrary to law, place and date of filing, name and signature prosecutor, title, and then the witness. And then again, the certification. Okay? All right, so that's it for the discussion on practical exercises. We've covered all the topics under the 2025 Bar Syllabus on practical exercises, no? So, believe in yourself, no? You are braver than you think, more talented than you know, and capable of more than you imagine. Kayang-kaya niyo yan. Believe in yourself, no? Malapit na, no? Malapit na ang finish line. So, kaya niyan. Trust the process, okay? He has made everything beautiful in its time. No, always pray and believe and trust God, okay? That everything will be worth it. Lahat ng paghihirap nyo, lahat ng mga sleepless nights nyo, mga puyat nyo, everything will be worth it, no? When you pass the bar examinations. Okay. So thank you again for listening, and you may reach me through my socials, my YouTube channel, your bar exam coach, Attorney Jen Estabilio, on my Telegram, my X or Twitter, and then my Facebook account. Okay. So thank you very much. Good luck and God bless. So I am looking forward to welcome you all in the legal profession. Okay. I am rooting for all of you.